9:03 a.m. and I detect a quorum, so we can get this meeting started. I will ask our board secretary to take the roll.
Chair Diani.
Present.
Ms. Butler is not present. Ms. Carpenter.
Present.
Mr. Gutierrez.
Present.
Mr. Sabas is not present. Mr. Wilson.
Present.
Ms. Young.
Present.
And Councilmember Porterfield is not present.
So that is 5 board members present. We have a quorum. We may proceed. That brings us to the second item on the agenda this morning, public comment period. And I will ask our board secretary, Mr. Kyle, if there is anyone signed up.
Yes, we have one individual signed up. Ms. Lauren Magley.
Okay. Okay. Speakers who sign up will have be limited to 2 minutes. The public comment period does not apply to ethics and lobbyist matters on the agenda, but any other matter can be discussed. So if you would like to.
Hello, everyone. My name is Lauren Magley. I wanted to first thank you guys so much for being here this morning. I know that it is early and that it is cold, and I promise you that we do not want to be here either, but it is very important, and that is why we were here. Of course, I'm not going to speak on anything to the agenda, but I did want to take a chance to introduce myself to you guys and introduce Rachel Gladstone and Chris Remke, who will also be here shortly, and just put a face with a name and let you guys know that we are real people that care deeply, deeply about our community. I'll start with talking about one of my newest friends, Rachel Gladstone. She has lived in the Nations for 23 years. She lives in a lovely historic home. She has got a crazy dog named Nancy Drew. She is a professional wedding planner and also a published novelist. I call her the hostess with the mostest. And if you ever get a chance to try her homemade chili, it's definitely something you're going to want to take up on because it is absolutely fantastic. Chris Remke, he is joining us later, but he's not here right now. I call him Remke the Remedy. He is one of the smartest and most intelligent men that I have met. He is a fierce truth teller.
Ms. Magley, 40 seconds left.
Thank you. He's a fierce truth teller, even when sometimes that opinion is not popular. Myself, I'm a third generation Tennessean, born and raised here. I love this city. I love my community. I love this state. I believe in local government. I believe in ethics. That is my strongest guiding principle as a human and in my profession. I know that you guys have an extremely difficult job here. You are the last line of defense for the people and for the truth to be told. So I just want to thank you and commend you so much for being here this morning and for listening to us. Thank you.
Okay, that brings us to agenda item number 3, approval of the minutes of November 24, 2025. Everyone has received a copy of the minutes in their packages. I trust that everyone has reviewed them carefully. And if there's no discussion, we can just get a motion for approval of the minutes. Motion. Okay, and second?
Second.
Okay, so we have a motion to approve and a second. Is there any discussion? Hearing none. All in favor of approving the minutes of November 24, 2025, say aye. Aye. Any opposed? Anyone not voting? Okay, so the minutes are approved. Thank you. So that brings us to agenda item number 4, notice of appeal rights, and I will have Mr. Kyle provide that notice.
After a contested hearing by this board, a party may appeal to the Chancery or Circuit Court of Davidson County by filing a writ of certiorari within 60 days. Any party wishing to pursue an appeal is encouraged to seek independent legal counsel to ensure that deadlines and procedural requirements are satisfied.
Thank you. That brings us to item number 5, discussion and analysis of the complaint and Department of Law's memorandum, re Chris Remke et al. Versus Council Member Roland Horton. So we will now turn our attention to this matter. And first of all, there are no recusals or disclosures at this point, I understand. So we can now begin discussion. I will say that one preliminary matter prior to beginning, as we do, with asking a law department to summarize the Department of Law memo, I will note that board members have received in their email a document from an attorney, and I believe it was a memo of law of some sort, that was sent to all of our emails. I don't know if anyone has reviewed it or read the memo of law. As our policy has been that when we receive anything directly from a third party, that we are not to review it. That has been our process and our procedure, because at this preliminary hearing, what we are to take into account is the complaint and the memorandum of law provided by the law department. That is spelled out in our procedures, which we adopted in 2023. And these are posted on the website, on our website. So our procedures, which we have formally adopted on December 8th, 2023, the procedures and organizational rules of our Board of Ethical Conduct expressly state in paragraph 3C that proceedings at meetings to evaluate the Department of Law's report called by the chair, we shall consider the averments contained within the complaint and the report submitted by the Department of Law. Upon conclusion, we shall make a determination of whether to set a hearing on the complaint or whether to dismiss the complaint in whole or part. No testimony will be taken at the meeting to evaluate the Department of Law's report. And then significantly, the next line says, no written materials other than the complaint and the Department of Law's report will be considered at the meeting. And I want to point this out because my instinct was to read the memorandum of law. I did not, because our process is to not consider anything outside the four corners of the complaint and the memo of law. But we all did receive it, and I did think that perhaps we could decide to look at it, to review it, pause and review it. However, seeing that our rules specifically say that we will not consider anything outside the law memo and the complaint at this meeting, I think we would, in order to comply with our own rules, we would have to amend our rules that we adopted on December 8th, 2023, in order to pause and read the memo of law from an attorney who submitted it to us. If we were going to change our own procedures and amend them, we would need to do that prospectively so that everyone would know, all parties would know. So I wanted to just raise that with the board to see if there's any thoughts, questions, or if there's a general consensus on my thinking about it, that if we were going to amend our rules in order to read it for this purpose of today's hearing, that we would, well, we couldn't without doing it prospectively. We'd have to like put it on an agenda item so people would know we were going to be holding a public meeting where we would consider changing our rules going forward to allow individuals or attorneys to submit memos to us that we would read in advance. So it'd be a significant change in our process. So I would just want to raise it for the board and ask for comments and thoughts so we can see if we can have a consensus. Thank you.
Well, thank you, Chair Diani, for explaining and reminding us of what our rules currently say. I saw that the memo came into our email inboxes last night, but I did not read it. I wasn't exactly remembering what our rules said, but I thought that it wasn't appropriate to read it, so I just didn't. And I don't think that it would be appropriate or necessary to amend our rules in order to allow us to read the supplemental material. I think back when we adopted the rules, we had, good reasons for doing so in the interest of efficiency and moving the process along in a fair manner. So I don't see any reason to veer from that at this point.
Does anyone else have any thoughts or comments about this?
Yeah, because I also think it's like a poor digital practice to open unsolicited attachments. So even if we did something like this, it would have to be centralized where I'm not opening emails from strangers.
That's a good point. Okay. Anyone else with a comment or thought? No? Okay. So I guess what I'm hearing is a consensus that at this point, there is not an interest in putting an amendment to our rules on some future agenda that we can change, that keeping our current policy and our procedures intact and respecting them today is the way to proceed. And I'm sensing a consensus there. So that is how we will proceed. Okay, great. Okay, well, thank you all. So that now moves us to this next part of this hearing or this meeting, which is to start, as we always do, with the law department and Attorney Ecke briefly summarizing the memo of law, your memorandum of law regarding this complaint. I will say it was kind of an extensive analysis, so I think kind of a summary of it would be great. And then we will undoubtedly get into discussion of more of the specifics of the law memo as we go, but kind of an overview of it would be helpful at this point. Thank you.
Thank you, Madam Chair. This ethics complaint arises out of zoning legislation sponsored by Councilmember Horton and a recall petition initiated by Ms. Magley for removal of the council member from office. There are 3 categories of factual allegations which are the basis for the claims that the council member violated the standards of conduct. I'll briefly address these 3 categories of factual allegations. Allegation number 1, the complaint alleges that the council member violated the standards of conduct by posting or encouraging the posting of Ms. Magley's name and address information on an Instagram post, and by issuing a media statement to WSMV4 in response to the recall petition that named Ms. Magley and stated that she lives in a home owned by her parents. Section 2.222.020L of the Metro Code provides that employees shall not use or disclose, other than in the performance of their official duties or as may be required by law, confidential information gained in the course of or by reason of their positions. The names of individuals who provide comments during meetings of the Metro Council are not confidential under the Tennessee Public Records Act. Also, the name and address of the initiator of a recall petition are not confidential under state law. It's the opinion of the Department of Law that the allegations concerning the disclosure of Ms. Magley's name and address in an Instagram posting and in a media statement issued to WSMB4, if true, would not give rise to a violation of Section 2.222.02L of the Standards of Conduct. Section 2.222.020M of the Metro Code states that employees shall not violate the direct or indirect conflict of interest, consulting, lobbying, or any other requirements of state law existing or which may be adopted regulating the conduct of municipal or county officials or employees. The Department of Law analyzed state laws addressing the criminal offenses of official misconduct and official oppression. Legislators enjoy broad First Amendment rights to express their views on public issues. It's the opinion of the Department of Law that the allegations in the complaint concerning disclosure of Ms. Magley's name and address in the context of the zoning legislation and the recall petition do not rise to the level of official misconduct or oppression as defined in state law. The Instagram post did not contain any threats and was deleted shortly after Ms. Magley contacted the council member and expressed concern. The Department of Law also analyzed Section 39-17-320 of the Tennessee Code, which prohibits the posting of the home address of an individual with the intent to cause harm or a threat of harm to the individual or a member of the individual's family or household. The Instagram post sought to refute Ms. Magley's alleged public comment at a council meeting that she did not know about the zoning plan until she got a notice in the mail. The Instagram post did not contain a threat of harm. Also, the Instagram post was removed once Ms. Magley contacted the council member and requested that the post be deleted due to safety concerns. It's the opinion of the Department of Law that the factual allegations in the complaint do not rise to the level of the offense set forth in Tennessee Code Section 39-17-320. Allegation number 2, the complaint alleges that the council member contacted a neighbor and directed her to call the police on recall petitioners at England Park, Charlotte Park, and Richland Park. The complaint asserts that police arrived at the Charlotte Park location, informed petitioners that they did not have a permit and needed to leave. Section 2.222.020I of the Metro Code provides that employees shall not use their Metro government positions improperly to secure unwarranted privileges or exemptions for themselves, relatives, or others, provided, however, that this provision does not preclude employees from acting in a manner consistent with their official duties or from zealously providing public services to anyone who is entitled to them. A permit is required under the Metro Code to erect stands or conduct appeals on Metro Park's property. Contacting police to report unpermitted activity on Park's property would generally not qualify as an employee securing unwarranted privileges or exemptions for themselves or others. It's the opinion of the Department of Law that the factual allegations in the complaint concerning directing police call to the petitioners for the activities on Park's property do not meet the definition of the offense of official oppression as set forth in Section 39-16-403 of the Tennessee Code. Allegation number 3, the complaint alleges that during an event at a local business, a volunteer from the council members' camp said that the recall petitioners couldn't be there, even though the owner of the business gave permission. The complaint further alleges that the council member texted the owner of the business multiple times, expressing surprise at the recall support, and continued to text and call the business owner despite her request to stop. The offense of harassment outlined in Tennessee Code Section 39-17-308 includes intentionally communicating a threat to another person, communicating with another person without a lawful purpose, with the intent that the frequency annoys, offends, alarms, or frightens the recipient, and by this action annoys, offends, alarms, or frightens the recipient, or engaging in bullying or cyberbullying. Bullying and cyberbullying refer to acts performed by students enrolled in a public or private school that conducts classes in any grade from kindergarten through 12th grade. The alleged acts of interference attributed to the council members' associates do not reflect threats to the recall petitioners or others. The communications outlined in the complaint between the council member and the business owner fall short of the definition of harassment as set forth in Tennessee Code Section 39-17-308. In summary, it's the opinion of the Department of Law that the facts alleged in the complaint, if true, will not give rise to a violation of the standards of conduct.
Thank you for the summary. Thank you for the memorandum of law. It's a lengthy analysis, and I just to kind of frame it, to think about what we're looking at standards of conduct, which we all know well, we look at a lot, and we're looking at certain provisions. The I, which is about unwarranted privilege, and we're looking at L, which is about not releasing confidential information. And then we're looking at M, which we're somewhat familiar with. M kind of reads in state law to it. And here specifically, the state law that was examined by the law department's memo was to look at state law involving official misconduct, official oppression, disorderly conduct in the form of kind of a colloquially called doxing and harassment. Those were kind of the provisions of state law that are looked at because they would be read in through M of our standards. So that's the kind of structure, as I understand it, of how the legal analysis is designed and formed and addressed, how the legal analysis is addressed of the complaint. So that's the legal side of it, and the kind of factual allegations that we're looking at and considering do fit into these kind of three factual areas of this notion of the Instagram, conduct relating to the Instagram account, and the, I don't know if it's News Channel 4, WSMV4 interview. I guess that's a print. So those two statements, as one of the factual, the incident or factual allegations that we're considering. The second is the directing the, alleged as the directing of the police calls to the petitioners, being in touch with either directly or through a third party to have the police involvement. And then interference, it's called interference. We can call that the private business, the Tin Wings incident that involved both alleged a campaign associate confronting a recall volunteer, saying they can't be there, and communications, council member communications with the owner of the business. So those are the three kind of factual areas that we need to look at against both the standards of conduct as well as M, which then reads in all of those state laws. So one way to do it would be to just take one of those, just do this, the factual allegations separately. You know, take one, address it, discuss it, and then the other, and then the other. And if we agree that that's an appropriate way to proceed, I would suggest that we may perhaps start with the second or third rather than the first. So perhaps we can look at this idea of, on the memo, it's on page 4 of 15 of the memo, it's number 2, address this, then go to the next one, address the tin wings, we'll call it, incident, and then come back to the Instagram statement. That's just a proposal of how we can proceed. Are people comfortable if we proceed that way? Okay. Yes.
Thank you. Good morning, Chair. Not opposed to it, just wondering the rationale of starting with number 2 as opposed to number 1.
Yeah, that's a good point. I think I was thinking that there would be, I think I was thinking, and you're right, and I appreciate the call, because I think it does suggest that I'm weighing in here. So you're right. I mean, I think that I was thinking about what I thought would be, for me, more straightforward. Less discussion to narrow, to see where our focus is. I had the sense that, but it doesn't matter. And if you have a preference, we can just go straight through. That's fine. Okay, if that's your preference, that's good. Okay, so let's start with number 1. The Instagram.
Can I just?
Yes. Yeah.
We might need to remind our audience that we can't take messages from the audience.
You are legally allowed to hold signs as long as they are not blocking the view from people behind them.
I guess,
Well,
or that
we don't have
evidence. We don't take.
Okay, I didn't even notice it. So I think that I think that what we can do is not pay attention to it. What we
Okay, I just want to make clear that on the record that we're not to than what's in the complaint at this point in the memo of law.
Yes. Yes.
Under our rules.
Okay, yes, that's a good reminder that as we went through before we were all gathered, we are only to consider the complaint in front of us and the memo of law. We don't take comments from the audience, and I don't think we need to go beyond that. Okay, but yeah, I hadn't even noticed, but okay. And I will say that, as we all know, so some of our board members are newer than others. As a board, we are a community board. We are not employees of the metro government. We are aided and assisted by having a law memo provided about the law that's applicable. But we, as an independent community board, may adopt the recommendations or reject the recommendations in whole or in part of the law memo, of the law department. So just because the law department makes the recommendation, we don't have to follow the recommendation. And in the past, we have sometimes not followed recommendations in whole or in part. So I just am also putting that on the record, particularly because there's some newer members. Okay, so we are going to proceed 1, 2, 3 as it's laid out. And we will start with the factual allegations regarding the Instagram account and the WSMV4 interview that was, I think, in the paper then. The allegation is that it led to harassment. Those two things. So we have, as I'm sure everyone has really looked both at the complaint carefully, the exhibits of the complaint, which we all have had, and I trust have looked at carefully. And this would be, so we're talking about Exhibit A, and then related Exhibit B of the complaint, Exhibit C, D of the complaint.
If I could just make an observation, just for the record, starting with number one, and the allegation that Ms. Magley's information was posted, her name and address information were posted on Instagram on August 18th, and then a statement was made by the council member on October 6th pertaining to Ms. Magley. The recall petition, it looks like, was noticed on October 3rd. So it appears that at the time of August 18th, when the information was posted, Ms. Magley hadn't noticed the recall petition yet. So I don't think it changes whether her name was already in the record as being opposed to the development necessarily, but it appears that it hadn't been disclosed via filing for the recall petition at that point. Just wanted to make that clarification for the record.
Yes.
So we can
I think that,
do away with all the signs.
well, I think that my understanding of the facts and the exhibits is that at that point, Voices of the Nations had been created in opposition to it. But you're right, I noticed that as well. October 3rd was the filing of the notice of intent to recall. So that is much, much later. So how does that, so tell us more then about how you factor that in.
Well, I think that the law memorandum made clear that the name and information wasn't confidential because, sorry, maybe someone else can jump in. I'm struggling to find the.
Because if you look at the exhibit, the exhibit has Exhibit A, the Instagram account, right? If you look at, 3/4 of the way down, that you have a meeting of 3/25/2024, where I believe there you have, it's redacted here. So I don't.
Memorandum of law, and to come at it, it wasn't confidential information on.
Yes. There is suggestion within the exhibits that there was a relationship, and it is not clear, and they don't say he posted it or had someone post it on his behalf or was somehow contributed or connected to the posting. That's what we get from the facts as alleged, that he somehow was behind it, because we do see from the exhibits, it appears that when they complained to him about it posting, I think we have an exhibit where he said he'll make a call, and then it came down. So it's not direct evidence. We don't know. I think reading the complaint and the exhibits, we don't know who posted it. I think they allege enough, and the exhibits suggest there may have been some involvement, and we don't know.
So I didn't read it that way.
Yeah. Okay.
In the text message that's in the exhibit, it says the account is Voice of Nations Lies. And the person who said that said, "Who the hell is this? They're
Right.
following all of us."
Right.
Good work, Ryland. And to which the council member said, "I can't talk right now." And then the council member's next message said, "Sorry, didn't get home until late now on the work call. Should be free again after 9." So saying that they couldn't talk
Right.
then. And then they said, but at 9:03, the call is going over. I'll call you when it's over.
Right.
So it doesn't look like the council member saying that they are calling someone to have anything removed.
Right.
What I will say is that if it says, "If I can, I'll message it to request to be taken down,"
Right.
saying that they are going to message the Instagram account requesting that this be removed. We do have constituents to reach out to us about things, and for me, it would not be uncommon if a constituent reached out to me to complain about something. To then say, like, "Hey, can you remove this?" That doesn't mean that they necessarily had a relationship with the owner of the Instagram account or was behind any of the posting on the Instagram account. Many times, supporters of legislation or projects, like, we can't control the way supporters show up and how they treat people that are in opposition to the things that they support. So I don't see anything that is tying the council member to this Instagram account.
Can I just?
Yes, I agree with that.
I think the issue is that we don't know, and that is something we would have to take evidence on if we decided that if the allegations in the complaint as taken as true actually arise to a violation.
Well, can I interject there? Even assuming that Mr. Horton was behind the Voices of Nations Lies account or somehow connected to it or in control of it, if what they posted wasn't unlawful or a violation, then why does it matter if he was or wasn't?
So I agree with both of those statements. It's a fact question. We don't know if he was behind it or not. He did say take it down, and it came down. But to the last point, and the legal memo addresses even if he were behind it, it doesn't rise to the level of the offense alleged for the reasons stated in the law memo. So I think that's why law department even dealt with it that way, because factually we don't know. So I think we almost we say it's relevant whether he was behind it or not, so much so that we'll go to hearing to find out that fact, or even if he were involved in or created. I mean, we almost have to assume the worst case, that if he created this Instagram account and posted this, would that constitute the offense alleged? If not, then we don't have to go to hearing to figure out his involvement or not. If yes, then we need to go to hearing and get him on the record to tell us what happened. That's why I was going to start with the other two, actually. I think a little bit more complicated.
I'll just say again, the way that I approached this was assuming the worst case scenario, assuming that everything that's in the complaint is true and it paints, the picture that it's intended to paint for us in terms of Mr. Horton's interference with the whole process of the recall petition and, trying to stop the signatures from being collected. Even if all of that activity is true, including creating this account, posting the resident's name and information, it still wouldn't be a violation of law or the code of ethics. So I don't think that we need to go to hearing. I think it's expected that we take the allegations as true, and even the inferences that are created by the allegations, which is that he had some control over this account. And from my perspective, even if he posted it himself or directed someone to post it, it still didn't violate the law or the code of ethics. So I don't see a reason to take evidence on that issue.
Okay. Do we have more comments on this before we move to the second? And we're going to then come back and, look at everything, but let's just get a sense of how we feel about these three issues. So we've kind of talked about this one. And if there's no more discussion on this one, let's move to the next one. This idea of perhaps, again, alleged driving around, seeing people trying to collect petition signatures at public parks, Richland and so forth. And then I think alleged that had someone contact the police to come to see if there was a permit, there wasn't a permit, they required a permit, and they had to leave. And there was a second allegation in this whole thing of in the same incident of a supporter, I think, showing up at one of the parks and sitting there. And again, the allegation is an interference with the collection of the petitions. To our council members' comment, certainly council members can't control what their supporters or what anyone does other than themselves. Certainly, if the council member asked someone to call the police to see if there was a permit, or directly called the police and said, hey, folks are collecting petitions, can you go see if they have a permit? Again, for the reasons stated in the law department memo, that doesn't constitute an unwarranted privilege because anyone can call the police and say, hey, can you go check if there's a permit? There's nothing unwarranted about it. Any member, any neighbor who saw folks there could have said, hey, just go check to see if they have a permit. There's a reason there's permits are required. So I don't know if anyone has a different thought about that in terms of being relevant to our code provision, the standard of conduct I, which disallows council members unwarranted privileges.
I couldn't tell what the unwarranted privilege would be in that situation. If we could maybe talk about that.
I read it as like weaponizing the city or like weaponizing police against constituents. But I agree with the chair's assessment, though. If it is anyone can call MMPD and ask about a permit. So I think it would be different if there was a call put in saying to harass someone or to arrest someone or to threaten someone. But in this case, if it's just saying, can you check and see if someone has a permit, I don't see that as any type of abuse of privilege.
I mean, there's no allegation that it had anything to do with role as council person. That's the thing. If anybody can do it, then a council person certainly can do it. There's no abuse of power. There's no and there's no allegations that I see that were described by our council member. But any other thoughts about this set of facts?
I'll just say that I see that it's not a good look for the council person to be engaged in this activity, particularly, when residents are trying to engage in the civic process and voice their displeasure with him as an elected official. It looks bad to be, interfering with the recall process. But again, we're confined by the code of ethics that we're, we have jurisdiction over. And unfortunately, I don't see anything related to this fact pattern that gives rise to a violation here. So I just wanted to acknowledge that it's not a good idea as a council person to be, engaging in this activity where your constituents are trying to follow a process that's set out and provided for them under the local laws. But again, we're bound by the code that's in front of us, and whether or not there's a violation there.
Yeah, we might get to a general assessment once we go through all of the facts to see if there's anything that we're seeing factually, any of the factual allegations that, if were true, would be a violation of either our standards of conduct, I, unwarranted privilege, L, confidential information, or M, any of those state laws, which are misdemeanors and various kind of criminal conduct. Are we seeing any allegations and we can then figure out what we are looking at, but let's just see if there's any factual allegation that if we went to hearing and they proved what they alleged is true, that it would be a violation. There'd be an ethical violation. And we are here today assuming everything they say is true. That's our task today. Everything they allege, we're going to assume it's true. We're going to, as has been stated by other members, we're going to assume the worst case, that council member did all of these things as alleged. Would it rise to the level of an ethical violation? And again, it has to fit into one of the standard of conduct, or including M, which brings in the state. So on the directing the police, it's this lack of permit, and then it further alleges that a supporter, right, sat beside the booth to intimidate the signers. And the petitioners filed an incident report. And I believe what are the facts there? I think the police, I believe the police did arrive and check to see if there was a permit, and there wasn't a permit, and a permit was required, so they left. So that if there's no more, so again, we're just touching these three factual incidents now, getting some preliminary thoughts from the board about them, and we can then go into more depth as anyone wishes. But that would take us to the third, the interference. This is the Tin Wings issue, that there was someone outside that, again, taking the facts as true, the local business owner gave permission for the recall volunteers to be physically on the property owner's property. They were attempting to collect signatures, and a volunteer came who is alleged to be a Horton worker, so someone in the council member's camp it's alleged, came and insisted that they couldn't be there. It's not clear what the consequences of that was, if they left or not. And then we have communications, and here we have direct conduct by, again, council member. We have the text messages. There was, looked like there was a call that was missed, then there were text messages exchanged, and then there was another call missed, as I read the exhibits. And so there was that communication. So one, having someone, arguably an anti-recall person, said you can't be there, even though the business owner had given them permission to collect signatures there. And then you have the council member call and text the business owner expressing surprise at the recall support. And in that case, we do have, as I read it, we do have the business owner saying, don't call me. And as I read the evidence, and everyone check me, as I see the exhibits, it looks like there was one call an hour after the business owner said, don't call me. It looks like there was one more call as I see it. And the question, and we should all talk about how we see the exhibits and whether we see it that way or differently, or what we take from the allegations and the exhibits to support the allegations. Anyone's thought on that? But the complaint then alleges is that conduct by having someone opposed to the recall petition say you can't be there, you can't do this. We don't know if they were affiliated with the council member or not, but we have to assume the kind of worst case scenario that the council member somehow was involved in having them go to tell them they can't be at Tin Wings. We have to kind of assume that. And had the council member done that and then called the owner even once after the owner said, don't call, those are kind of like the description of the kind of worst, the kind of, if the council member did all of that, does that rise to the level of misuse of public office, abuse of power through retaliation, improper influence, interference with a citizen's petitions, undermining public trust? Well, that's what it's alleged, but the question is, would that bundle of, if that conduct were all proved, and we're going to assume it's all true, would it rise to the level of a violation of a specific standard of conduct or one of the state law provisions that are set forth in the law memo? And perhaps holding for the moment to the side what Ms. Young was talking about, whether any of this conduct was ideal. I mean, holding that to the side for a minute kind of concerns with council members' conduct if all these things are true. Hold that to the side. We're looking more, right now, we're looking at if all true, does it rise to the level of these standard of conducts, I, L, or M?
Can I ask
Yeah.
a question to Metro Legal? Yeah. So the allegation that there was harassment of the Tin Wings owner, who is not a complainant in this action, assume that the board determined that fell into the definition of harassment. Can the complainants, do they have standing to complain about harassment of the Tin Wings owner in this situation? Or does the Tin Wings owner need to bring that complaint against the council person?
We analyzed this that anyone can bring the complaint. That's the way we looked at this.
Because the harm to the public is unethical behavior by an elected official.
So is the standard or the law that's implicated here harassment? Is that or is there something else we're looking for?
Harassment is, I believe, is read in through M, our
Right.
standard M. There's a state law which deals with the issue of harassing behavior, and I think it is. Yeah, on
Page
page 13. Yeah, page
there's,
13.
The
It's
Tennessee
called,
Code section.
yeah, 308, 3917, 308, the address of offense of harassment. And, the law memo tells us what you'd have to show in order for this conduct described to rise to the level of a violation of that state code section read into our standards of conduct through M. And that's where I have trouble, because what we have is, what I saw in the evidence was one call that was missed, then an exchange where the council member said, I just tried to call you. There's an exchange back and forth. We don't see the end of that call. It clearly was unhappy in some ways because she said, don't call again. And then from the timestamps on it, it looks like an hour later, there was another missed call. obviously, it's not if someone says don't call, you shouldn't call. You shouldn't call back. I mean, that's what don't call means. Don't call me. So if the facts, as I'm reading the evidence, are that then he called an hour later, that wasn't appropriate. The definition, the state statute of harassment, means a communication with another person without lawful purpose, anonymously or otherwise, with the intent that the frequency or means of communication annoys, offends, alarms, or frightens the recipient, and by this action, annoys, offends, alarms, or frightens the recipient. I don't believe that one follow-up call an hour later that just was missed, and that's all we see, constitutes that conduct, communicating to frequency or means that would intended to annoy, with the intent to annoy, offend, alarm, or frighten. There's just no factual allegation. Now, if there are other facts, like he was calling 24/7, called 15 times, we can assume that would have been in the complaint. So what we have is a missed call, an email, a text message exchange, and an hour later a follow-up call that was missed, and then nothing more.
So one issue I have with that is I don't think we at this point should be defining intent. And that's a hang up I have. I think intent would have to go to what the proof shows. And one of the reasons I asked the question about the recipient of this is because if you look at the Tennessee Code section, it says the frequency or means of the communication annoys, which I, again, think it was based on what I read, offends, alarms, or frightens the recipient. And so the recipient is the Tin Wings owner. And so the Tin Wings owner would have to be the person testifying, at least if we're analyzing under this section. And so, and then I think the recipient would have to testify about the effect it had on the recipient, and I think there would have to be proof of intent or not. And I don't think this meeting and hearing is the time to determine that.
Well,
but since she's not a complainant, I don't know if she'd be called as a witness or not. I mean, that's the issue I'm having here.
well, so if the record shows there was a missed phone call, a text message, and then a follow-up missed phone call an hour later, and that's the universe of the conduct that we're looking at, because that's all that's alleged. I don't know how we can get from there to the suggestion that the frequency was intended, the frequency of the communication was intended to offend.
It says means or frequency, I believe.
Right, right, well, okay.
And she does say, please stop calling me, and he says, he immediately, I don't know if it's immediate, he responds with, sorry to bother you, everything all right. He continues to contact her.
These are text messages, right?
Correct.
This is one
on
exchange, right? This is one exchange, yeah.
Right.
Yeah, yes.
And forgive me because I am an Android user, and this appears, I'm assuming this looks like iPhone to me. This doesn't look like the way my text messages roll out. But it shows there's a missed call at 2:12, and then the text exchange starts at 2:12, but there's not a timestamp that shows when the text exchange ends, but we do have a timestamp that the missed call is at 3:12.
Right.
So we don't know if all of this, we don't know if that second missed call was before or after the text that said, please stop calling me. So that, I think that is, we don't know if the person continued to call after being asked to stop. Like, we don't know if they said, please stop calling me, and then the person called, or if the person called and then they said, please stop calling me, to which they said, is everything all right? There's not a continued, like the text thread ends there where the person just says, I'm not sure what you're referring to. I don't know how far we have with like leniency of like making assumptions, but I would assume if the council member continued to like harass or continue to send messages, those would be included in the complaint. If the person is saying that they are like the frequency to your point, if they're saying that this person is continuing to contact, I think we would have evidence of that and we would have screenshots of that, and we don't. It looks like it stopped here. I don't know that this rises to the means of harassment based on the TCA code. And in the code, it specifically outlines intentionally communicates a threat to another person. There wasn't a threat there. Communicates to another person without a lawful purpose, anonymously or otherwise, with the intent and frequency or means of the communication that annoys, offends, alarms, or frightens the recipient. It looks like the communication stopped here. Communicates with the intent to harass. I don't know if we can have, I don't know if we could look at intent, but it doesn't appear that it arises to the level of harassment. And I also want to acknowledge what Ms. Young said earlier. Like, I don't think that we should be making any assumptions that it is okay to communicate with someone after they ask you to stop communicating. I just don't think that it is clear that that communication, that call happened after the text message saying, please don't call. It's not clear if that call happened before or after, and none of these messages are threatening messages, and they don't rise to the definition of bullying or cyberbullying. So I don't see how it rises to the threat according to TCA code 3917-308.
So if we look at, this is how I look at the exhibits. Look at Exhibit K attached. Here's the thing about Exhibit K. It starts with the second Exhibit K. Okay. So at the top of the second Exhibit K, Roland Horton, Saturday, October 18th, 2:12 p.m. Hey, Leanne, Roland Horton here. That's the start of it. They go through, it looks like one continuous back and forth coming down. This is their conversation. It then goes to the next page. You see there's a duplication here. So just skip down to the bottom. So go to the first Exhibit A. And at the bottom, he says, over the neighborhood plan, she says, please stop calling me. Sorry to bother you. Everything all right? I'm not sure what you're referring to. That's the end of what we see here. Turn the next page to the third K, and you see his screen. It's October 18th. So there's a 2:12 missed call, which is consistent with him saying, I just tried to give you a call. Then there's nothing, and then there's a 3:12. Then there's the text exchange, and then a 3:12 missed call. So that's what the documentation of the harassing communications is. Those things. The two missed calls, one of which he refers to in the exchange. So if you're saying we don't know if that 3:12 missed call was before or after
The please stop calling me
the
text
please
message.
stop calling, this feels to me, we don't know. You're right, we don't know. But again, assuming worst case, because then we have to go to hearing. We have to assume worst case that this 2:12 text messages, he tries to reach her, he texts her, she responds by text, they go back and forth. She says, please stop calling me. And then that's a continuous texting starting at 2:12. It ends, and then later there's a follow-up 3:12 call. That's worst case, that he literally put in a call after she said, please stop. The question is, even if that's true, does that rise to the level of the state statute on harassment, where the communication specifically designed to harass? The intent is so frequent. The means could be, calling in the middle of the night, calling 5 times in the middle of the night to disturb someone's sleep. I mean, that's telephone harassment. Is calling one time after someone said, please don't call, does that conduct possibly rise to the level of criminal conduct, criminal harassment? That's what I'm having trouble with. Was it great? No. And this goes back to Ms. Young's. I mean, we can talk about that, but does it satisfy the elements set forth in the state law? Let's get some more thoughts in here on this. Others, thoughts, thinking, what is kind of reactions, general feelings about it? Any comments, any thoughts? What you're hearing, what you've read? Anyone down here at this side of the table?
Yeah, so I don't feel that they rise to the occasion of harassment. And then even looking at the other kind of code ethics thing, there's no misuse of his position in this text exchange. So, and
So you're not in this text exchange. You're not seeing anything that, and
Do we need to take into account the allegation in the complaint that says Merrick, who's the recipient, felt, quote, upset, alarmed, and fearful of future retribution, close quote? I mean, I'm just having trouble here because this person is not a complainant, but there's allegations that she had a reaction that might be consistent with this definition.
so what you're. I think I'm hearing you say, well, there wasn't an affidavit or something from
Right.
her, right? It's just an
There's
allegation.
nothing.
So
Yep.
the question is, really, I think what some of us are all saying is, was there more conduct that we're not seeing
Right.
because the description of the harm by the conduct that we're seeing doesn't necessarily match up? I was surprised to read that there was a missed call, a communication, and then a follow-up call an hour later, and that was so alarming to someone. I mean, I'm surprised that didn't match up to me, to have someone, even after you say, please don't call me, if someone put in a call, called you an hour later, and that was it, you didn't respond, you didn't speak with them, and that was it. I was surprised to see the allegation that this business owner was so troubled by it.
I'm less surprised that Ms. Merrick was troubled by it. I don't think that we should assume or inquire or try to find out if there was more conduct than what was alleged here, because we just have to go off of the complaint as it's presented to us. And I think it's possible that she did feel upset, alarmed, and fearful of future retribution by virtue of the associate, the campaign associate, confronting the recall volunteers at her establishment, and then Mr. Horton questioning her about allowing the recall petitioners to use her establishment. I think that was like the totality of the circumstances in addition to the text messages and the calls. But even taking all of that on its face, I don't think it's harassment, quite harassment. Even if she felt upset, it's just the frequency and the means part is what's like operative there, not just how she felt. I don't think, the number of text messages and 2 calls would check the frequency box. And the means, a text message and a phone call and 2 phone calls. Like, I don't see anything between frequency or means that would give rise to harassment here.
Again, during the business day, not at 2:00 in the morning. So, yes, I agree with that. I think, I know what I'm struggling with is that I'm not happy about this totality of behavior. It's very uncomfortable. It's concerning. When you put it all together, it is not what I certainly, what we would expect if, I think someone said it, on the petitions, like, let it be. So you don't have to be there and see if they have a permit. Let it be. Let the process happen. Let the chips fall where they may. So there's some behavior. You don't call someone after they say, please don't call me. It's just not the high standard of, conduct that we might wish. And so, but it is not whether we would applaud all of these various behaviors. It's a matter of whether the facts as alleged in the complaint, even if all true, rise to the level of an ethics violation under our standards of conduct, unwarranted privilege, release of confidential information, or M, bringing in the state law. And that's what I think the lawman was helpful, because it tells us what the law is and what the elements of the law is. So we'd have to see that the behavior alleged, if true, which we assume, would satisfy the elements of the state law. And that's what I'm not really finding in the complaint as alleged. Again, there's a suggestion that there's more stuff that they could tell us, but it's not here.
Sorry.
No.
I didn't mean to interrupt. I wanted to make a point about that as well, where the complaint says, this is by no means an exhaustive list. We have several more events of Horton's intimidation and repeated appearance at recall petition sites, as well as digital harassment via emails and social media. At your request, we will present this additional evidence. I have to assume that the worst would be in the complaint, right? Like whatever the worst, most egregious behavior that they feel crossed the line would be in the complaint. So if it's more of the same types of conduct, which is how I read this, it's more of the same types of conduct, I still don't see how that additional evidence would bear out unless the harassment was of Miss Merrick to Ms. Carpenter's point. But she's not a complainant. So that makes me, I'm just kind of on the fence about that. Like, if he continued to reach out to Ms. Merrick and, the frequency then reached the level that was harassing, then maybe. But I have to assume that that's not the case here because it's not in the complaint.
Right. I think, I don't know how we can start reading in additional facts to try to save a complaint from dismissal. I think the question is whether, if the fact were true, it would be a violation. That's when we go to hearing, because then we go to hearing to see, is that fact true? I don't think we can start saying, well, if he did a lot of worse things, then we'd go to hearing. I
agree.
Just don't. So I think that the reason this is challenging for us, I know for me personally, is that given the totality of the behaviors described, it's a little disappointing. The behavior is a little disappointing. It's like, wow, not the ideal way we would like people to respond. But that we're not here to judge whether this was ideal behavior. We're here, we have to be able to, if we were going to go forward to hearing, we'd have to know what behavior we were going to go test. What conduct are we going to go see if it's true? Because it would be a violation. And that's what we as a board are trying to figure out. Is there anything in this complaint that, if it were true, it would constitute a violation that we could then move forward and sanction? That's the only reason we'd go to hearing. I want to distinguish one thing. I feel in some ways, and I think the struggle I'm having is because generally it doesn't feel like great behavior. And generally, I can understand how members of the public can be unhappy about this, feel like, wow, that falls well short of standard of conduct that we expect of our elected officials. And I think very much, I do think that it is concerning if the council member was part of the Instagram. I think even the comment to the newspaper was a little snide. It was a personal dig. And I understand why in an ideal world you'd say you don't want your council member talking about you that way to the public. I understand, it's hard. I don't know why anyone would want to be a council member, but we, in an ideal world, we'd like our, let it be, rise above it, and, so I have problems with the conduct, but what I don't see is a violation of the standards, either our standards, IL, or I certainly don't see anything that gets pulled in through M. I don't see any suggestion of criminal conduct here at all. I see falling short of being your best, falling short of holding the line at a high level of professionalism, integrity. That's what falls short. And here's the thing. So that's where I put it. So there is something which for public officials, we don't have a general statement of ethical standards that's just, a standard to maintain a high standard of honesty, integrity, impartiality, and conduct, essential to maintain the confidence of the citizens in government. We don't have to forbear from doing anything that could adversely affect on the confidence of the public and the integrity of the government. We don't have a general ethics standard for elected officials. We do for employees, certain employees, through executive order. And the complaint mentions executive orders, and I'm looking at legal to correct me when if I misspeak, but the complaint does talk about executive orders, but the executive order that speaks to general standards of integrity and so forth doesn't apply to public officials. It only applies to, and I'm looking at Executive Order 5, which was adopted by our current mayor, Executive Order 5 of the Berry administration.
Is that in our packet? Because I didn't get that.
It's not.
Yeah, it's not, but I don't think there's any executive order implicated here.
No, it's right, but there is an executive
these
order which has this general ethics standard of a high standard of integrity, honesty, don't do anything that could, but that's for employees. That's executive branch employees because they're hired. Public officials are hired by voters. It becomes a question of voters hire council members. They can fire council members. So council members are not subject to this executive order. So I agree with legal. But I think that for me personally, that's where I feel like it fell short of the highest standard. But I don't see a violation of the standard of conduct.
I'd like to circle back to the first allegation that's been characterized as doxing Ms. Magley. And the question, I just wanted to make clear on the record is if her address was not public and he posted the information that identified her living at a specific address, is that a reason to find a violation?
Well,
I just want to make sure that for purposes of the record, and if this case, goes up on appeal, that we've addressed the specifics, not just her name, but also her address.
Yeah. So let's look at the legal analysis on that, the law department's memo.
And we understand that she is a renter at this address, so she wouldn't have been listed in the tax assessor's website. And the excerpt from the meeting that was posted appeared to list an intersection and not a specific address or parcel and street number. So the question is, if her address wasn't public and it was posted on the Instagram post, is there a violation there?
So what is the confidential information? Oh,
Well, that's
you're
my
saying- no,
question.
you're saying,
Is her
yeah.
address confidential information?
Well, in August, you're saying?
Yes,
prior
on
to the
August
prior,
18th.
prior to the recall petition, right? being
Correct.
filed.
According to the law memo, it's not. It says the name and address of the initiator of a recall petition or not. Okay, that
Yeah,
goes back
that's
to
a
the
recall.
timing.
That's
October.
Timing. But,
Right. At this point, she wasn't a recall petitioner
it says
when it was
similarly,
posted.
and then it says similarly the names of individuals who provide comments. It doesn't say the names and addresses during meetings
Correct.
of the council or public information. So
I guess
that's how you're parsing it.
Right,
Yeah.
right. If her name is public, she spoke at a meeting,
Right,
so
right.
people know, okay,
Right.
that's who this person is. But her address wasn't public. So would posting her name and address, together in this post be disclosing confidential information that would violate the standards?
So just to clarify, when constituents come to give public comment, they give their name and address on the
Address, right.
record.
That's right.
So it's not just them saying their name, it is them saying their name and their address.
So is that something that's just a practice, or is it required?
It was part of the rules to make sure that people live in Davidson County, and we actually changed the rule this term because of the divisive nature of our country right now, and because so people tend to threaten and are so hateful right now.
right.
We actually changed it that you don't have to disclose your exact address. You can disclose like your council district, your neighborhood. It has always been the person says, my name is this and I live at this address. Now we say, you can say like your council district or your neighborhood or your address.
When did that change
Well,
happen? Hold on. When did that change happen?
That change happened at the beginning of this term, so that would have been fall of 2023.
But so in the record that we have from the public meeting that was posted, it didn't list her address. It listed her intersection or, something like that.
That's from a community meeting. That's not from the council public meeting. So we're looking at two different meetings. That looks like a nation's neighborhood meeting for the information that was posted. A council meeting is where is what I'm referencing, and that's what it appears to reference in the legal memo where it says similarly the names of individuals who provide comments during meetings in the Metro Council are public information. So that's the one that I was referencing.
Right. It didn't say address.
So without having a video or going back to see what information she gave, we don't know. I don't know if she gave her address or not. I can't remember every constituent that spoke at these meetings. Like this legislation went on for an extended period of time, and we had lots of constituents come out to speak. So I have no idea if she gave her actual address or her neighborhood when she spoke.
Right, so that's a factual question, but you said that the council has changed its rules so that members of the public do not need to give their physical address. They can give a crossroads or just that they're in what council district they're in, right? So that you can speak at a public council meeting without giving your exact address as of, you said, the beginning of this term.
As of fall of 2023. Most people still give their address, but
Right.
you can choose
To not.
to not give your address.
So that opens a factual question then. I mean,
I think legal
yeah,
has a point.
go ahead.
Yeah, I just want to clarify. the issue of confidentiality. So the code section talks about disclosure of confidential information gained in your official capacity. So it's situations where there's a Metropolitan record that's confidential, not public, that someone then uses. If someone obtains information through another public means, like on a website from the accessor, that's not confidential information in the possession of the Metropolitan government. So, so that rule talks about confidential information that someone obtains. You know, usually we're talking about records of Metro that are confidential, that are released to the public.
I understand that the tax assessor's website is not confidential information.
It's not.
I understand. But if someone is not listed in the tax assessor's website, for instance, because they're a renter, only the property owner's name would be listed with that address in the tax assessor's website. So as a renter, if you're not listed there and the council member obtains your address through some other means, I guess the question is, when is your address confidential if it's not listed in the tax assessor website? Are there other ways that the council member could have gotten the address that wouldn't have been him using his position to access a confidential record?
Confidential, okay, just wanted to clarify. Confidential information is information in the possession of the government that under the law is deemed confidential and non-public information. So if someone goes on a website and, you know, puts a name and an address shows up and they assume that that name, you know, maybe a family member, etc., is where someone lives. That, again, that's not confidential information in the possession of the government. The key issue is, what is it that's confidential in the possession of Metro that was released?
Right, and so that's why I brought this up, because I want to make it clear on the record. Our question here is, was confidential information posted? So I'm just trying to make sure that we have agreement, or that we address the specific question of whether her name and address being posted is not a violation because it wasn't confidential information.
Okay. So I really appreciate that, and I think this conversation has clarified that the definition of confidential information being used here only speaks to our standard of conduct I, which relates to confidential information. The allegation is different. It's in addition to that. The allegation is under M, reading in 3917-320, the disorderly conduct provision of the state law, which makes it a criminal offense to post personal information with intent to cause harm. So irrespective of whether it was available publicly or not, this is the allegation that this Instagram posting was, you know, to use the colloquial doxing, you know, was trying to cause harm. So that's on page 9 of the law memo. It doesn't say anything about confidential information to Metro government. That's not a disclosure of confidential information under standard code I, subsection I.
I think we're looking at L, though, aren't we?
Yes.
Oh, I'm sorry, L.
Yes,
You're right,
okay,
L. That's
okay.
right, sorry.
Sorry.
Yeah, L, thank you. So it's not looking at confidential information. It's looking at was home address posted, telephone or home address of an individual, and this is the key language that the law memo emphasizes, posted with the intent to cause harm or a threat of harm to the individual or a member of the family or household. The code provision goes on to make it clear that as used in this statutory provision of the state law that disallows this posting of personal information to cause harm, that the harm they're talking about is bodily injury or damage to property. based on the statutory requirements of a violation of this state law read into our code through subsection M, the law department said it doesn't, you don't have the underlying facts alleged to allow you, even if the council member was involved in the posting, it doesn't rise to the level of this offense. And this is why I was going to make this third, because I think this is the hardest part of the, for me personally, of the case.
Yeah, I agree that once we get past whether this was a violation of L, I agree that it's not, because it's not confidential information gained in the course of or by reason of their position. So then looking to the state law that talks about intent, with the intent to cause harm or threat of harm to the individual or a member of the individual's family or household. I think the memo from Metro Legal does a good job of providing the context of the post. And when you look at the context, it's basically refuting some alleged public comments that the resident made to draw out the fact that they did have notice of whatever it is that was being debated at the meeting. There was nothing in the post that called for violence or destruction of property. And I think it was noted that the post was deleted and there hadn't been any comments to that effect of anyone saying, I'm going to harm you. So I would come down on the side of finding that it doesn't rise to the level of being a violation of this Tennessee Code 3917-320 for that reason.
Yeah, I don't disagree with that, and I believe there was a police report calling it unfounded. I do think that it is, and I understand the context, and I appreciate that, yes, this was in a larger context of a zoning dispute and trying to refute a certain statements made on the record. However, that could have been done in a very different way. I think the intent of the post is to call a member of the public a liar, and I think reputational harm to have it posted. So I find it concerning behavior, but I agree with the analysis of the law department that the elements of the state law are not satisfied for the reasons you said. But I do find it concerning behavior if the council member was behind this, which we have to assume that there was involvement. Now, that may be a real reach, and sometimes it's good to go to hearings so that a respondent can clear their name when there's been allegations. But we couldn't justify going to hearing unless we say this behavior alleged would be, if it were true, and I don't think any of us are finding that those allegations of behavior that would constitute a violation. That said, I find it concerning. I find this post concerning. I think falls well short of an expectation. If, again, we don't know, but if the council member was behind this post, we have no reason to believe, as our council member here pointed out, we have no reason to believe that he had anything to do with the post. So this is.
But again, assuming that he did.
Yeah, we have to assume he did, and it still doesn't rise.
We're still saying that assuming that he was behind the post, it still wouldn't be a violation of the ethical code or the state law.
Yes, if our standards of conduct for elected officials had a general standard of integrity, honesty, and so forth that employees of this government have, are required to under Executive Order 5 of the Barry, which has been adopted by our current mayor. If that standard existed, I would go to hearing on that standard, because I think the behavior as alleged, whether it's true or not, and we don't know, but as alleged, I think it falls short of the standard under the Executive Order 5, which is a high standard of conducting yourself with integrity and impartiality and honesty and all that. And I think a behavior of having anything to do with posting on Instagram something designed to say one of your constituents is a liar is problematic. But we just don't have elected officials are hired by voters, and voters can fire them for conduct. And it is not for us. We don't have a general high standard of conduct that we can sanction for elected officials. So we are limited to the specific standards of conduct for which elected officials are responsible. And so that's the kind of a bit of a hole that I feel like this case presents for me personally, because I'm not, if everything they allege is true, I'm not satisfied that that's okay. But it doesn't fit into a violation of our standards of conduct, including M, which pulls in the state laws. And so there's something dissatisfying about it. But we are limited to very specific jurisdiction. So, other thoughts?
I just want to put something on the record. I think we're having, I think there are kind of two different conversations that we've had here today. I do think it is prudent to assume the worst case scenario in the event to see, does it rise to the occasion to say that there has been a violation. And in each of these instances, when assuming the worst case scenario, we are in agreement that it does not, it seems as though we're in agreement that it does not rise to violation of any of the TCA codes that have been listed. So I think that's one conversation. I think the other conversation that I would hope that we can be careful and cognizant of is, because there's been, multiple statements of being disappointed with the behavior of the council member, and I think that we may just want to be careful with the framing of that. And the reason that I say that is because, even looking at if the council member did go to the place where the park where the recall was happening, I think there's a difference in behavior of this person was threatening, intimidating, yelling, cursing, doing something like that, which none of this alleges. We also get constituent calls where constituents are saying they're not comfortable in situations. So, we can't make an assumption either way. We can't assume that constituents said, hey, we're uncomfortable because people are out here harassing us to sign something and we don't know if they have a permit. And we also can't assume that the council member was on the other side harassing the petitioners. Him showing up in a public place does not, I don't think his behavior should be impugned for simply stating that he showed up at a public place. So I just think that we should be careful. If all of the worst case scenarios, if we assume that every single worst case scenario is true, then I think it is fair to say that there may be concerns about if this behavior is fitting, but I don't think that we can make an assumption to impugn the character of an individual when that is not the task at hand. So I just want to be careful of that.
So obviously, let me clarify if you misconstrued anything I said, certainly. We haven't found any facts. We have no idea what the facts are. We are not alleging any facts. We are not assuming any facts. So if there's any confusion there, we were looking at we were assuming worst case facts. And what I was certainly trying to talk about was, even if you assume the worst case facts, you have nothing to move forward to hearing on. However, worst case facts are not happy facts. So it was only looking at the allegations of worst case facts, literally even having to assume that council member was behind the Instagram. I think because as a community board, we need to also kind of give our sense of, to the larger community, we like what feels acceptable or not. That's why I mentioned sometimes you go to hearing because the respondent could actually want to go to hearing to make it clear that, because if you just dismiss it all, no one knows who's been involved with what. That's the nature of it. So we have the only fact, I think the only facts we have are from the exhibits are a phone call after being told not to call, which I think is immaterial, which is nothing. So, but I think what I certainly was trying to say is, it's not that this behavior is all fine and we'll dismiss it because there's no problem here. As alleged by the complainants, there is a concern here. That's what I was saying. And I don't know, I know others have said there's some concern. I mean, to distinguish, we are not stating anything about the respondent here, because nothing about the respondent's before us. He's not here. There's no facts. It's a very odd, first step of a larger process. We just have to decide if there's anything to go to hearing on, in which case all the facts would come out and we would know what happened here. But I agree with our council member that I'm hearing consensus that no one is finding anything in this complaint as guided by the law of the law memo that would suggest it's appropriate to go to hearing. Is that where we are? Okay. And I don't know if that is sufficient, if my response was adequate. I mean, do you?
Oh yeah, no, I do not think that anyone's intent was to disparage anyone
Okay.
yeah. So it's fine.
Okay. All right. So may I have a motion?
I move to dismiss the complaint in its entirety because the allegations, as alleged, do not constitute a violation of our ethical standards of conduct or state law.
Okay. May I have a second?
Second.
Okay. Any further discussion? Hearing none, let's do this by roll call.
Chair Diani?
Yes.
Ms. Carpenter?
Yes.
Mr. Gutierrez?
Yes.
Mr. Wilson?
Yes.
Ms. Young?
Yes.
That's 5 in favor, 0 against.
The motion passes, which means that the complaint will be dismissed. We will file a final order to that effect, probably, if not in the next few days, probably after the holiday, in the first week of January. We'll get that out. Okay, great. Okay, well, thank you. That concludes this matter. We can go to the next steps in scheduling. There had been a suggestion about amending our procedures. I understood there was consensus that we would leave our procedures as is, so we don't have to put that on the calendar. We don't currently have any other matter pending before us, so that the next step is just to mark your calendars for the first annual meeting. The next annual meeting, which is the first Monday in March. First Monday in March. Okay, that's that. And if there are no other questions, may I have a motion for adjournment?
So moved.
Seconded? Okay. And all in favor, say aye. Aye. We are adjourned. Thank you all.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.